Welcome to today's program titled Overview of SEC's Crowdfunding Proposals. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by selecting the chat pod located in the lower left corner of your screen. Then type and send your questions that way. Our presenters will be addressing questions throughout and at the end of the presentation as time allows. This presentation has been prepared by Seyfarth Shaw, LLP for informational purposes only and is not legal advice. This information is not intended to create, and receipt of it does not constitute an attorney-client relationship. Participants should not act upon this information without seeking professional counsel. The material discussed during this webinar should not be construed as legal advice or legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. Any tax information or written tax advice contained herein, including any attachments, is not intended to be and cannot be used by any taxpayer for the purpose of avoiding tax penalties that may be imposed on the taxpayer. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form sent with the login information email. Please write this code down. It will not be reread, and it is required for CLE. The form will also be re-emailed to you in a few days. There will be an archived version of the presentation available. A follow-up email with ordering instructions will be sent to you later this week. At this time, I would like to turn it over to one of our presenters, David Warburg. David?
Good afternoon for those of you on the East Coast. Good morning to those of you further west, and good evening to those of you who are joining us from further east. Our topic, overview of SEC's crowdfunding proposals, is one that we've been awaiting with some interest. We've been tracking as members of the practice group the development of crowdfunding, and now that we have actual proposals from the SEC, it's a useful and opportune time to review them. With me are Michael Dunn, Vice Co-Chair of the Securities Practice of Seyfarth Shaw, and Georgia Quinn, who's a member of our Securities Practice Group. What we're going to cover today is crowdfunding. And crowdfunding has taken on many meanings. It's probably useful to identify what we are not discussing. We're not discussing donation-based programs because those are not securities and they're of great interest but not to securities practitioners. We are not discussing private placement financings by accredited investors that are used only by accredited investor-only transactions using funding websites, nor are we discussing the new effective rules under the Securities Act, under the Jobs Act, that allow public solicitation in certain private placements. What we are discussing is crowdfunding under Title III of the Jumpstart Our Business Startups Act, the Jobs Act. This is not your teenager's vision of crowdfunding. That will become apparent as we go through this. But it is, importantly, to those of us who practice and operate in the capital markets, either as sources of capital, as users of capital, or as intermediaries, this is the SEC's proposed implementation of a very novel technique, perhaps not novel to today's technology-conversant environment, but novel certainly by the standards of the 75-year-old securities regulatory environment which we've had in the United States since 1933. We will cover what crowdfunding is. We will cover who the primary participants in a crowdfunding mechanism will be issuers, investors, and intermediaries. We'll cover the disclosure requirements that are imposed by the proposed regulation on issuers and on the intermediaries. We'll discuss offering regulations, including the requirements for investors in terms of their qualifications. We will discuss intermediary regulations at some length, those requirements that are imposed on intermediaries, and we will discuss Bank Secrecy Act requirements and fraud prevention, which is a focus and concern for the SEC as they propose these regulations. And lastly, we'll touch upon liability, of course, of interest to lawyers and persons acting in the financial and capital markets on a regular basis. On October 23rd, the SEC proposed the new crowdfunding rules required by Title III of the Jobs Act. We'll discuss the key points as they affect the participants. As mentioned, there'll be an opportunity to submit questions. We'll try to take them at least one point during the presentation and take them again at the end of the presentation. Please feel free to submit questions as you wish. So what is crowdfunding? Title III crowdfunding under the Jobs Act is an exemption from registration of an offering under the securities laws. It's a new exemption. It's different from the exemptions we've all come to be familiar with. It's different from 506, both old and new. It's different from 504. It does cover an investment provided in exchange for securities of the issuer. So, for example, in that respect, it is very different from a donation-based program where the recipient does not have any expectation of profit or any return from their donation. It covers both debt and equity, although the focus and much of the chatter, so to speak, about crowdfunding has been on equity funding for startups in particular. There is no reason both under the Act or under the proposed regulation why crowdfunding could not equally apply to debt financings, and there are any number of smaller companies who may wish to use it for debt financing, either on a secured or unsecured basis. Crowdfunding is an offering of securities to the general public regardless of accredited status. That is probably the most basic distinction that it has as compared to the other exemptions. But coupled with that ability to offer to the public, regardless of their accredited or lack of accredited status, is that crowdfunding will require the issuer to use an online intermediary. And the stress is on online. We are finally getting away from the paper environment that has dominated the securities regulatory environment in terms of debt disclosure for decades. Crowdfunding will also implies, and the regulation encourages, crowd-generated feedback and dialogue to help make the investment decision. And that is an overview of Regulation CF. If you look at the diagram, and I hope you can all see it on your screen for those who are dialing in only by phone, we've tried to present a graphic of the crowdfunding mechanism. You have investors, appropriately colored green, who are providing investor commitments to the intermediary, the portal, so to speak. The funding portal will refer to the funding portal as an intermediary. And they in turn, and those investor commitments, when accepted and in accordance with the offering rules, will be transferred to the issuer. The money, you'll notice, does not flow through the intermediary. One of the requirements of Regulation CF is that there be a separate escrow agent. The intermediary cannot custody investor funds. So, as really a fourth participant, perhaps a quiet one, but essential one, in any crowdfunding technique or fundraising, will be the requirement that there be an escrow agent. Now, online intermediaries have obligations. They could be existing registered broker-dealers. The regulation specifically contemplates that they may be, that an existing broker-dealer may establish a crowdfunding intermediary or portal as an adjunct to its existing business. There are any number of marketing reasons why an existing broker-dealer might choose to do so to develop entree to a set of issuers who it might not otherwise be able to approach, or who might not otherwise be interested in retaining it to provide financing services. Or the intermediary, the funding portal, could be a new registered entity. It will register under what we might refer to as broker-dealer light, BD light, but it will still be a registered broker-dealer subject to a subset, smaller but admittedly still significant subset of regulations that other broker-dealers are subject to. The issuer who receives the money and the benefit of the crowdfunding mechanism will have both initial and some ongoing obligations as a result of taking money in a crowdfunding placement. I'm now going to turn this presentation over to my colleague Georgia Quinn, who will talk about issuer limitations and requirements, investor requirements, and disclosure and reporting requirements, and offering requirements under proposed Regulation CF.
Thank you, David, and thank you, everyone, for joining us today. So we're going to begin our discussion with the issuers. And if you know anything about Reg CF, you probably know that issuers in a Reg CF offering cannot raise more than $1 million in any rolling 12-month period. This limit includes offerings of affiliates. Other exempted offerings, such as Reg D or other private placements, will not be added to this $1 million limit. So this offering can be done separate and apart without, interfering with another private placement. In addition, this offering would not be integrated with other exempt offerings. So you could do, a consequent Reg D offering following your crowdfunding offering and not be worried about integration issues. However, you do need to consider your public disclosure and public solicitation rules because, as we'll get to in a brief moment, crowdfunding offerings cannot involve general solicitation. Issuers must be U.S. companies. They cannot be foreign entities. They cannot be subject to the SEC reporting requirements already, so this is not for public companies. They cannot be investment companies or companies that have an exemption from the Investment Company Act, so hedge funds are also excluded from this rule. Issuers must be in compliance with Regulation CF if they have conducted a crowdfunding offering in the past. So if they have already issued Regulation CF securities, they must be compliant with the continued reporting obligations and other rules that we'll be getting to later in the presentation. The offering can't have any bad actors involved, and these bad actors are defined in the Jobs Act, and they include any party in the offering: the issuer, the issuer's directors, officers, general partners, beneficial owners of more than 20%, promoters, and compensated solicitors. And basically, if any of those parties have conducted these, any of these actions, which in general are being subject to a final ruling from a regulatory body barring them from being a member or participating in a financial-related industry, or individuals that have conducted fraudulent, manipulative, or deceptive conduct and been convicted of it within a prior 10-year period, and individuals convicted of any felony or misdemeanor in connection with the purchase or sale of securities, or that have been convicted of making false filings with the SEC cannot be participants in a Regulation CF offering. The issuer must have a business plan. Now, the SEC has not given a firm definition of what a business plan is, and they're purposely leaving this open to allow flexibility for startup companies. But they have stated that that business plan cannot be simply to engage in a merger with some unidentified target. Now we're moving on to investors. The amount that an investor can invest is limited based on its annual income or net worth, and this is basically a cut and paste from the Jobs Act. These rules are basically verbatim, and if an investor has a net worth or an annual income of less than $100,000, they're limited to investing the greater of $2,000 or 5% of their annual income or net worth. Now, if their net worth or their income is over $100,000, they can invest up to 10% of that, and that is up to $100,000. But any investor's investment under this regulation is limited, no matter what their net worth or how much they make, to $100,000 in any 12-month period. For the purposes of these rules, income and net worth will be calculated in the same way they are for Reg D, and that means you can combine your income and net worth with your spouse. You can include your primary residence in your net worth, etc. And then finally, and quite importantly, the issuer will be allowed to rely on the intermediary's determination of the income or net worth of the investor, and that determination will be based on the investor's own attestation. So there won't be a situation where an issuer has to go and independently confirm an investor's income or net worth by getting a letter from an accountant or looking at their tax returns. That is not what is envisioned by these rules. Instead, the other parties will be able to rely on the attestation made by the investor through the portal. And speaking of portals, on to the intermediaries. As we mentioned before, these offerings must be conducted online. The issuer may only use one intermediary for their offerings. The investor must agree to accept only electronic delivery of all information. So again, we are now in a paperless world. No more prospectus delivery requirements, no more mailing of information statements. This will be purely conducted in an online environment. It's currently an open issue, and the SEC has requested comments as to whether intermediaries will be able to restrict access to certain investors or groups of investors, such as people, limiting an offering to people located in one particular region or to investors that state they have a certain income level. And the reason you can see this creates tension is that if an issuer is only allowed to use one intermediary and can't, move to another intermediary during their offering process, they would want to have control over what types of investors they can access. And if the portal is going to have control over who can and can't invest, you can see the tension that will create. So the SEC has requested comments in that area. And then finally, intermediaries are prohibited from affecting secondary market transactions. So although the intermediary will be able to conduct the primary offering, if a secondary market develops between people who already hold these securities, the intermediary is not allowed to create a secondary portal for those transactions. So now we're moving on to the real heart of these regulations, and that is the disclosure requirements. The SEC has proposed a Form C that will be filled out by issuers and filed with Edgar, and also the information therein will be published over the intermediary, the funding portal. Of course, some common sense sort of elements are required: the name, legal status, form of organization, jurisdiction. You can read those items. The names of the directors and officers, all positions held within the company for the past 3 years by those individuals. The principal occupation and business experience of those individuals, including whether they were employed or are currently employed by another employer, and if so, the name of that employer. The names of any persons holding 20% or more of the voting equity securities. And I want you to pay attention. This is a 20% threshold, which is actually quite high when you think about the other disclosure thresholds that are used in other areas of securities regulation. And then finally, a description of the business and the anticipated business plan. And remember that business plan is not a defined term. It's specifically left open and available to give issuers flexibility. In addition to those kind of preliminary disclosures, financial information will have to be provided under Reg CF. Financial statements, such as the balance sheet, income statement, and cash flow statement, will have to be prepared in accordance with GAAP, and they'll need to be provided for the shorter of the last 2 fiscal years or since the time of inception. Now, a lot of people have been concerned about this requirement and the expense that will be involved in preparing these instruments, but it's also important to remember that Reg CF was intended in large part for startup and new sorts of enterprises that most likely won't have a long financial history. So the preparation of these instruments may not be as difficult as some people are anticipating. So the levels of financial statements that have to be prepared vary depending on the amount of financing that is being raised in the offering. So if the issuer is raising $100,000 or less, they must provide tax returns for the most recently completed fiscal year, and their financial statements must be certified by the principal executive officer. The SEC has also said that in the providing of these tax returns, the issuer is allowed to redact any personally identifying information to take care of any privacy concerns of an individual. If the issuer is raising more than $100,000 and up to $500,000, they must provide their financial statements that are STARS reviewed by an independent public accountant and provide an auditor report for those financials. And if the issuer is raising more than $500,000, they have to supply audited financial statements and an auditor opinion from an independent either AICPA or PCAOB registered accounting firm. One thing also to note is that financial statements that receive a qualified opinion would be in compliance, but financial statements that have an adverse or disclaimer of opinion would not qualify, and the issuer would not be able to conduct an offering. In addition to the financial statements, the issuer will need to disclose a narrative discussion of the financial condition, including historical results of operations, liquidity, capital resources, how the proceeds of the offering will affect liquidity, and other available sources of financing, and if no operating history, a discussion of financial milestones and operational and liquidity challenges that it expects to face. And, the SEC intends this disclosure to be similar to an MD&A disclosure, but not as detailed or lengthy. The next bit of disclosure we'll discuss is the proceeds and the use of proceeds. So an issuer must disclose the purpose and the use of proceeds. This disclosure needs to give an investor a sufficient description of how the investor is going to use these funds, or of how the issuer is going to use these funds. For instance, paying employees, paying the funding portal, acquiring assets. If there are a range of options and the issuer hasn't completely determined where it'll allocate the funds, it needs to disclose the range of options and the decision-making process in selecting how to use those funds. Also, they must disclose the target offering amounts and the number of securities offered and the deadline to reach such amounts. So for those of you familiar with crowdfunding, this is crowdfunding 101. You list your target, then you explain these are the securities, this is what you're going to get for the amount of money, and then the deadline. If we don't reach it by this certain date, then the offering expires, funds are returned. In addition, the issuer has to provide updates regarding the progress of the offering. It has to provide notice within 5 days of receiving 50% of its target amount and 100% of the target amount. The issuer also has to let participants know if it will accept amounts in excess of the target, and what, if any, upper bound it will set as to the amount of proceeds that it will receive. One thing to remember in this scenario where an issuer exceeds its target amount, if it exceeds its target amount and that puts this issuer into a new category of financial statement requirements, for instance, if it crosses that $100,000 threshold, is now going to receive proceeds over that amount, they will have to provide the financial statements that are required for that level of financing before they're able to accept those funds. Okay, so in addition to those items, the issuer will also provide disclosure around the mechanics of the offering. And this is going to be boilerplate because it will apply to every offering that's conducted. And this is really just a way for the SEC to get those rules out there and explain the way they envision the process taking place. So investors may cancel up to 48 hours prior to the deadline. The funding portal will notify investors when the target has been reached. The issuer may close the offering early if the target is reached, but it must give 5 days notice. If an investor does not withdraw within 48 hours prior to the closing date, it will automatically receive the securities and the issuer will automatically receive the funds from the escrow on the closing date. If the investor does not reconfirm the investment after a notice of material change has been provided, then the investment will be canceled and all those funds will be returned to the investor. One thing to think about in this scenario is if an issuer reaches its target early and decides to close its offering, it's required to send a notice of a material change in that offering because it has changed the target date. When it does that, if it does not receive reconfirmation from all of the investors that have signed up at that point, those investors' investments will be canceled and those funds will be returned. So if an issuer, reaches its target early, that's going to be a decision point as to whether or not it wants to just go ahead and keep its offering open for the full amount of time, or if it wants to take the risk of having to send notice out and making sure that that investor sees the notice and clicks and, is present when the investor may have just thought, I've submitted my, investment and my information, and they think that it's, a completed transaction. And then finally, if as we mentioned, if the investments do not equal or exceed the target amount by the target date, then the offering will be terminated and all the funds will be returned. So now on to the actual securities that will be issued under these offerings. The issuer will be required to disclose the price of the securities and the method for determining that price. You will also have to give a description of the ownership structure and the basic capital structure of the issuer. They will have to disclose each class of securities and the relationship and differences of those securities among one another. They have to describe the voting rights and limitations on the securities that are being offered and how the terms of those securities can be amended. It must disclose the rights of security holders and how they can be diluted, limited, or qualified by the rights of other classes of securities that are currently outstanding or that could be issued in the future. They need to provide a description of how the rights of majority shareholders could affect investors and the securities that they are issuing. And they need to describe the risks relating to minority ownership and associated with corporate actions and transactions with related parties. Basically, I think we can sum up all of these risks with, the Facebook movie. We can kind of direct investors to see the movie The Social Network, and this kind of explains all of these fears. And then finally, the issuer has to give a description of the transfer restrictions, and these securities do have transfer restrictions, and we will discuss those a little bit later. So just some other additional disclosure requirements. The issuer must provide the CRD registration number of the portal that they're using. They must disclose the amount of compensation that they're paying to the intermediary. They must provide certain legends, and these are prescribed by the rules themselves. These will, be pasted into the offering materials. They must disclose the current number of employees, any material factors that make the investment risky or speculative, and, this is similar to the risk factor section that you see in public offering documents and even private placement memorandums. This is, getting at those similar issues. They must disclose the material terms of indebtedness of the issuer, including the amount outstanding, the interest rate, the maturity date. They must disclose any exempt offerings that they've conducted within the past 3 years, and in addition to that, they must disclose the exemption that they were relying on. And then finally, they need to disclose any related party transactions in excess of 5% of the amount being raised since the beginning of the last full fiscal year. And for these purposes, the related party transactions would be any transaction between the issuer and its officers, directors, 20% holders, or their immediate family members. So in addition to the initial offering documentation and disclosure an issuer must provide, they also have to provide updates, and they have continuing reporting requirements. The issuer must amend Form C for any material change in the offer terms during the offer period. So as we mentioned before, if any of the terms of the offering, including the closing date of the offering change, they have to give notice, and they do this by filing a Form CA for amended Form C. In addition, issuers will have an ongoing reporting requirement for as long as their securities that were issued under Reg CF are outstanding, and that requirement is the filing of an annual report that must be filed on the issuer's website and through EDGAR within 120 days at the end of their fiscal year. Issuers will use Form CAR-C annual report, which will require information very similar to Form C and the offering information that was initially provided. Basically, the SEC expects issuers to use the Form C that they've already prepared and then go through it and update it on an annual basis for any changes and any operational updates that are material. Now, the reporting requirements will remain in effect until either the issuer becomes a public reporting company and then has to file a whole host of other, documents and is subject to other disclosure requirements, or until the issuer or another party purchases all of the securities that were issued pursuant to Reg CF, until the issuer liquidates or dissolves. And once any of these three things happen, the issuer must provide notice to EDGAR using the Form CTR within 5 days of one of those events happening. Okay, so now we're going to move on to the offering and the regulations surrounding the offering itself. We're going to start with publicity, and as I mentioned before, Reg CF offerings, crowdfunding offerings, cannot be public solicitations. So the only pure public notice that can be provided is a kind of brief statement that is, similar to the tombstone statements that you see in IPOs. It can state that the issuer is conducting the offering. It can provide the link to the intermediary, the terms of the offering, such as the amount, the price, the nature of the securities, and the closing date, factual information about the legal identity and location of the issuer, and then a brief description of the business. And, while this seems like a very limited amount of information, it's important to note that in this, character-limited media that we live in, where Twitter and other social media really can restrict the verbiage, this might just be enough information to then, direct someone to the funding portal where, the full offering information will be provided. And again, it's important to note that access to the funding portal will not be restricted. It is for the general public. And then finally, an issuer can participate in the dialogue with investors through the intermediary during the offering period. So, this is something very new and unique to crowdfunding. The SEC really envisions these chat rooms on the funding portal where prospective investors can pose questions to the issuer. The issuer can give answers and, provide an explanation, and then potential investors can speak to one another and really vet out and share their ideas about an investment. So that's, and that's really the crowdfunding unique part of these regulations. So now we're going to touch upon promoters in the offering, and there's really going to be a very limited role for promoters in a Regulation CF offering. First of all, an issuer cannot compensate any promoter who uses channels outside the portal unless it's limited to that little tombstone notice that I mentioned. There really doesn't seem to be much opportunity for that. Where the SEC envisions promoters being used is actually within the chat rooms, kind of posing as a potential investor and really pumping up one of the securities or pumping up an issuer. And, to the extent that a promoter does that, on each of the chats that they post, they'll be required to disclose that they are being compensated and the level of compensation and, the relationship that they have with the issuer so that it's clear that this person is an interested party. Oversubscriptions are the term that the SEC is using. Another way to really think about an oversubscription in this context is just receiving proceeds in excess of the target amount. The issuer sets an amount that they hope to raise, and to the extent that they raise more than that, the SEC is terming this an oversubscription. But it's important to note this isn't a typical, oversubscription green shoe sort of scenario that you see in public offerings. There is no limit to the oversubscription, and the issuers, except for the $1 million ceiling for any, Regulation CF offering in any rolling 12-month period. But again, it's important to note that to the extent an issuer exceeds the target amount, they will have to provide financial statements in that category of amount of money that they're raising. So, that could inhibit them from accepting any funding over their target amount. There is no fixed price requirement for the securities that are being offered, so securities may be subject to dynamic pricing, like an auction sort of scenario, or really any other sort of creative pricing mechanism as long as it is adequately and fully described by the issuer. And then finally, there are no limitations on the type of securities that can be offered or a set methodology for valuing them. So, as mentioned before, an issuer can do a debt, an equity offering, it could do warrants, it could do a hybrid instrument. Really, there's the creativity is really kind of endless in this field, and the valuation of those securities is, also kind of up in the air as long as the methodology is adequately described. If that piques an investor's interest and they're up for it, the SEC has not, at this point, put any restrictions on a situation like that. Now, the SEC has provided an issuer safe harbor because they understand that these will be, arguably unsophisticated issuers, smaller issuers, startup companies, and, these were 585 pages of proposing release. So it's a lot of rules. It's people that aren't necessarily used to wading through these kind of regulations. And so if an issuer runs afoul of these rules during an offering, to the extent it can show that its failure to comply was insignificant with respect to the offering, that it made a good faith and reasonable effort to comply, and that it didn't know that it was failing to comply at the time, the SEC has provided a safe harbor, and the issuer will not be found to be in violation of these rules. Okay, as I mentioned before, the securities issued under Reg CF do have transfer restrictions. The securities may not be transferred for 1 year after they are purchased unless they are transferred to the issuer, to an accredited investor in another private placement, as part of a registered offering, or to a family member. And these are similar to our Reg D transfer restrictions. So this is basically what we were expecting to see. And then securities issued pursuant to this rule will not be included as holders of record for purposes of Section 12G. So an issuer is not going to need to be concerned about the number of holders that they get, pursuant to this offering, and that might, push them up into a reporting company, and then they would have to be, a full-blown registered reporting company under the 34 Act. For the purposes of 12G, Reg CF holders will not be deemed holders of record. And with that, I am going to turn our presentation over to Michael Dunn, who also has some CLE information for you. So take it away, Mike.
Thank you, Georgia. So if you have a pen and paper handy, I'll go ahead and read the CLE code for today's presentation. That code is SS1272. Again, that code is S as in Seyfarth, S as in Shaw, 1272. Within a few days after today's presentation, you'll receive an email from Seyfarth with a form that you'll just need to complete with your name and contact information. Fill in this code and send that form back to us in accordance with the instructions provided, and you'll receive your CLE certificate by either email or mail distribution shortly thereafter. Again, that CLE code is SS1272. Before I jump into the provisions about the crowdfunding intermediary and how that's supposed to work, I wanted to take a moment and address some questions that have come up during the first part of the presentation. The first question was asking us to explain the nature of the risk factors that are required in the crowdfunding offering. The nature of the risk factors are the same as those risk factors that are required to be disclosed in connection with any other private placement or public offering. It's basically the fundamental risks in connection with an investment or the business operations and results of operations and financial condition of the company. So the SEC is not creating a new disclosure standard with regard to risk factors. They're just applying the existing disclosure requirements regarding risk factors to crowdfunding as they've done with other forms of offering. There was a question about the restrictions on access to an intermediary platform, and specifically whether an issuer could restrict access. As Georgia indicated, there are a lot of open questions about, to the extent that access can be restricted, and that's obviously one of the questions that we as lawyers and I think people in the market have, principally in the context of an issuer. If an issuer can request that an intermediary deny access to the platform from prospective investors who have participated as plaintiffs in a class action suit or some other securities law related suit against an issuer in the past, to the extent that there is an activist investor who's looking to invest in crowdfunding, obviously I think issuers would be interested in exploring ways that they could prevent those types of investors from participating, and whether or to the extent they'll be able to do so is an open question for comment under the rule proposals. In addition, there was a question about secondary market transactions. As Georgia indicated, the crowdfunding intermediary is prohibiting from affecting secondary market transactions, but it's important to note that that prohibition applies to transactions through the crowdfunding platform. So as we'll discuss in a minute, if it's a funding portal that's registering as an intermediary, then that would function as an absolute prohibition. However, if it's a traditional broker-dealer that's registered under Section 3A4 of the Exchange Act, who's running the intermediary platform, then that broker-dealer would be permitted to engage in secondary market transactions, but it could not do so through the crowdfunding platform. It would have to do so outside the scope of the crowdfunding platform, and we need some further clarification from the SEC staff on whether they could receive inquiries from those on the crowdfunding platform and refer them to a different group or team within the broker organization to address those secondary transactions. As the rules are written now, though, it would only be a prohibition of those transactions through the portal. Lastly, we've received a question if we could sort of distinguish crowdfunding from other forms of exemptions that are currently available. David, I know this is something we were discussing yesterday. I sort of view crowdfunding as another option on the table for early stage issuers in assessing their capital raising options. Again, as we discussed in our webinar in June, I think Rule 504 under existing Regulation D provides a viable option for companies if they are looking to raise $1 million and can do so through privately solicited transactions, because the the requirements under 504 are less extensive than crowdfunding, but to the extent you need to go public and get funds, crowdfunding is not a mutually exclusive option, and it provides a viable, alternative in addition to other options under Reg D or Reg A. David, I don't know if you want to comment further on that.
No, I think you're right, Michael. It's going to be crowdfunding, and we'll talk about it some more at the end. It's going to be one of the array of alternatives that a financing professional and legal professional have to collaborate in looking at in terms of the benefits versus the costs and the burdens.
Okay, yep. So now that we've addressed those questions, and again, feel free to submit, additional questions as we continue the presentation through the chat feature in the webinar. We'd be happy to address them in real time as time permits.
Let me take two that popped up, Michael, because I think we can address them right now. Mm-hmm. One question was asked is, can a foreign company set up a U.S. affiliate and use Regulation CF to raise funds through or for that affiliate? The question is not the question. Of course, people on a more basic level, people ask, why are foreign issuers prohibited from using crowdfunding when in the past the SEC has generally taken a more relaxed regulatory view toward foreign private issuers, that when they go public here they're subject to less onerous regulation in some respects. I think it goes back to the title of the act that proposed crowdfunding. It's the Jumpstart Our Business Startups, and the accent is on the hours. And notwithstanding that the EGC provisions of the emerging growth company provisions of the act are available to foreign private issuers, crowdfunding by the legislation is not. I think it would be very difficult for a foreign company to set up a U.S. affiliate unless it was crystal clear that the securities being issued by that U.S. affiliate will never, ever, and cannot represent a claim on either the future profits or assets of the foreign parent. So, for example, if the foreign private issuer set up a U.S. sub, the U.S. sub made the offering through the portal, and the securities were at some point convertible into or exercisable for shares of the parent, I think the SEC would almost certainly take the position that that's a violation and that's a securities offering that's not permitted under Regulation CF. Another question that was raised is, may the issuer be an LLC or a limited partnership and not a corporation? And the answer is yes. There's no restriction in the crowdfunding statute or regulations on the nature of the issuer. Conceivably, it could be a trust. There may be restrictions, practical restrictions, on using an LLC or an LP interest because there may be tax ramifications if the number of equity participants in the entity reach a limit, but that's a tax issue and that's not a securities limitation. Michael, go ahead.
Thank you, David. I appreciate you covering those questions. So we're now moving into the portion of the presentation that talks about intermediaries. As Georgia mentioned, for an issuer that's conducting a crowdfunding offering, that offering can only be conducted in reliance on Regulation CF solely through a single crowdfunding intermediary. And there are two types of parties that can function as a crowdfunding intermediary. The first is a traditional broker-dealer that's registered under Section 3A4 of the Exchange Act. And the second is a new class of broker-dealer called a funding portal that's defined under new Section 3A80 of the Exchange Act, which was added pursuant to the Jobs Act. Now, just a somewhat humorous note here, the Jobs Act actually added two different Section 3A80s to the Exchange Act. One is, of course, the definition of funding portal for purposes of regulation crowdfunding and the crowdfunding rules. And the second is a definition for emerging growth companies under the relief from the public registration process that is available to those entities. So unfortunately, it's just an example of one hand not knowing what the other is doing through the legislative process. So the references to 3A80 throughout this presentation are the definition of funding portal, not the emerging growth company definition. Section 3A80 defines a funding portal as a person that's going to act as a crowdfunding intermediary, but that does not do the other types of things that a traditional registered broker under 3A4 would do. Namely, a crowdfunding intermediary cannot offer investment advice or recommendations. It can't solicit purchases or sales. It cannot compensate employees, agents, or others based upon the sale of the securities that are available through the crowdfunding platform. And again, that prohibition is consistent with the SEC staff's enforcement view that any person who receives transaction-based compensation has the salesman's stake in the transaction that is, the primary and principal, function of a broker, and therefore, if someone is receiving transaction-based comp, they need to be registered as a broker under 3A4 and don't fit under 3A80. A crowdfunding intermediary that's registering under 3A80 as a funding portal cannot hold, manage, or possess investor funds, and they cannot engage in such other activities that the SEC may prohibit. So one point that we wanted to clarify at the outset is that a funding portal, although it's separate from a traditional broker under 3A4, is still deemed to be, for purposes of the federal securities laws, a type of broker under the Exchange Act. And that's important for several reasons that we're going to discuss later. It is noteworthy that, at least as proposed, Regulation CF does not create any additional prohibitions on funding portals other than those that were identified in the text of Section 3A80. However, it is, the Commission staff does discuss several times throughout the proposing release the fact that associated persons of a crowdfunding portal will remain subject to all of the restrictions, limitations, and obligations of the funding portal, the same as associated persons of a broker would be subject to all the traditional broker-dealer restrictions. So associated persons include, traditionally partners, officers, directors, managers, and other persons who directly or indirectly control or are controlled by the intermediary. So a person who's looking to register as a funding portal to function as a crowdfunding intermediary under 3A80 will be subject to existing brokers who are registered under 3A4 will be subject to the existing SEC registration requirements under Form BD. A funding portal that's looking to register under 3A80 will be able to do so using proposed Form Funding Portal, which we've characterized as Form BD Lite. It's noteworthy that intermediaries must register with the National Securities Association that's registered under Section 15A of the Exchange Act. Noteworthy that FINRA is the only such agency, so as of now, a funding portal will have to register both with the SEC as well as FINRA. And pursuant to those registration requirements, a funding portal is going to have to maintain a fidelity bond with a minimum of $100,000 in coverage. A full-blown broker-dealer shop under 3A4 has fidelity bond requirements substantially more than that, so $100,000 is a relatively low threshold and a bit of relief that the SEC and FINRA are offering persons who are looking to register solely as funding portals under 3A80. And lastly, another bit of relief for funding portals, they will not be required to register with SIPC, the Securities Investor Protection Corp. So the contents of Form BD Lite are here on the next slide. It's pretty basic, self-explanatory information, consistent with the type of information that is already required of brokers under Form BD that are for those that are registering under 3A4. The key difference is that Form BD Lite does not include all of the customer funds and custody and fiduciary type of disclosures and information that's required on Form BD, because funding portals, if they're acting only in that capacity for purposes of Regulation CF, will not be permitted to receive or process customer funds, and to the extent that customer investment funds under a crowdfunding portal go through a third-party escrow agent, it was not deemed necessary to solicit that type of information under the Form BD Lite. We were just discussing some questions that came up with regard to foreign private issuers or foreign entities that are prohibited from being an issuer under crowdfunding. Foreign entities are not prohibited from acting as intermediaries for purposes of the crowdfunding rules. However, there are some additional and, quite frankly, extensive requirements that would apply if a foreign entity or person attempted to register under 3A80 as a funding portal. Specifically, there has to be an information sharing agreement in place between the SEC and the regulatory agency in the foreign entity's jurisdiction. And that foreign entity would have to sign a consent and power of attorney designating a U.S. agent for service process. And more importantly, that foreign entity would have to certify to the SEC and to FINRA that FINRA and the SEC would have access to that entity's books and records as well as on-site inspection as a matter of law. And that has to be accompanied with an opinion of counsel for that foreign issuer that basically provides that as a matter of law under the foreign jurisdiction where that foreign entity is located, the SEC and FINRA would have a right to on-site inspections and access to be able to subpoena books and records of that entity without having to rely on some contractual provision that it would be attempting to enforce. The FINRA registration process for funding portals. FINRA has put out a proposal, which is FINRA Release 1334, that was issued last month. It's proposed Form FPNMA, which is under new proposed rule, NASD Rule 110A, which is modeled after the NASD Rule 1010 that applies to brokers. Basically, FINRA is following the same pathway that the SEC has in terms of having a consolidated, condensed, and much more streamlined registration process for funding portals as compared to traditional brokers registered under 3A4. So, for example, whereas a broker that is making an application under 3A4 to register with FINRA is subject to 14 standards that can be used to grant or deny an application. For funding portals, that has been reduced to 5 standards, which you see listed there on the screen. In addition, the FINRA registration process for funding portals reduces the application timeline from 180 days to 60 days. And there are other timelines and procedures that are reduced for funding portals. One key caveat that I would note is that while a funding portal must establish and maintain systems to supervise activities of associated persons, and they have to adopt written anti-money laundering policies, the same as brokers registered under 3A4, whereas brokers under 3A4 have to annually have an independent testing done of their controls and procedures and policies. Funding portals registered under 3A80 will only have to do that testing on an every other year basis. So a little bit of relief for them in that regard as well. In terms of restrictions that regulation crowdfunding imposes upon intermediaries with respect to their interactions with both issuers and investors, an intermediary is prohibited in any way, shape, or form at any time from having a financial interest in an issuer. It applies to the intermediary as well as associated persons. It applies to any direct or indirect financial interest, and it specifically prohibits receiving an interest post-closing or any time during the offering process as a form of compensation for acting as an intermediary. Again, the thinking being that if there's a financial interest in the issuer, that creates an incentive to make a recommendation or to provide advice, which is not the intended role and function of a crowdfunding intermediary. An intermediary is designed to be a platform and to facilitate dialogue amongst the crowd with respect to issuer investments, but to otherwise not provide advice or engage in any of the other prohibited activities under 3A80. The intermediary has to engage in an issuer verification process. They have to perform background and securities enforcement checks with regard to each officer, director, and 20% equity owner of each issuer that is requesting a listing. And an intermediary cannot offer securities unless it has a reasonable basis to believe that the issuer has established a means to keep accurate records of the securities it would offer through the platform. More specifically, as part of this verification process, The intermediary needs to either rely on a certification by the issuer, or if there are circumstances where just relying on that certification may not be reasonable, then the intermediary would have to independently verify the issuer's ability to basically maintain its books and records with respect to the items that are indicated here on the slide. So monitoring the issuance of the securities, maintaining a securities list, transfer log, ensuring legends and a control book demonstrating, registration of securities as necessary. All these types of normal corporate record keeping and transfer agent services, they need to be, reasonably, the intermediary must ensure that those are reasonably in place. In order for an investor to begin to, solicit, information or to engage in dialogue or to make an investment, they have to open an account with the intermediary. Pursuant to that process, the intermediary would need to collect certain information from the investor, as well as provide some mandatory materials under regulation crowdfunding, including educational materials and information that generally talks about the crowdfunding offering process, types of securities they may see, risks of an investment in a crowdfunding offering, transfer restrictions, and the investor limits. So basically some of the basics and fundamentals of the rule, that information has to be communicated to investors at the time of account opening. As I indicated earlier, there are certain activities that a crowdfunding intermediary is restricted from engaging in connection with the crowdfunding offering, but realizing that there needs to be some relief for certain types of ancillary services or mechanics and procedures that an intermediary would look to set up on its crowdfunding platform. The SEC proposed a safe harbor for certain types of activities. Well, it's interesting that neither the statute nor the proposed regulations define the term investment advice. The safe harbor nevertheless identifies the list of activities that you see on this particular slide that indicate that if the issuer if the intermediary provides these services or engages in these activities, it will not be deemed to be investment advice, and therefore it would be within the purview of a 3A80 funding portal, whereas if it offered investment advice, it would then have to register as a broker under 3A4 and become subject to the heightened regulatory requirements that entails. So, for example, adopting objective criteria to limit or highlight the securities offered on the portal. Examples of objective criteria that could be used to limit or highlight securities that the SEC discusses in the proposing release include, dividing or grouping investment opportunities by type of security, i.e. having different sections for debt and common, preferred or convertible equity, dividing securities offered by geographic location, industry segment, or the number or amount of investment commitments to date, progress toward the target offering amount, or to divide investments by the minimum and maximum aggregate or individual offering limits that may be imposed. All of these criteria were identified and discussed by the SEC staff in the proposing release as being permissible within the exemption. The two caveats are that, first of all, you cannot use criteria that are based on an assessment of the merits or shortcomings of an offering, and whatever criteria are used have to be reasonably designed to result in a broad selection of issuers and be applied consistently so that there is no risk of the criteria implicitly acting as a recommendation of a certain class of securities. We also see here that communication channels between investors or issuers, that's one of the requirements, and obviously one of the inherent functions of crowdfunding, is that there be discussion and analysis of the offering amongst the crowd to facilitate and assist investors in making an investment decision. So what the SEC staff has said in the proposing release is that neither the intermediary or its associates can participate in discussions other than to establish parameters and remove abusive or fraudulent communication. What's interesting is that if an investor wants to post comments or commentary in a communication forum through the crowdfunding portal, they first have to register with the intermediary. However, the crowdfunding intermediary, as a function of these rules, is required to make available to the general public at large all of the communications that are happening with respect to a listed issuer on that crowdfunding portal. And lastly, to the extent there are communication channels, the intermediary has to ensure that any person who is posting that may have a financial interest or a compensation arrangement in place with respect to the issuer or the intermediary, that relationship and that interest must be disclosed every time that person makes a post of information or makes some communication through the intermediary portal. As you can see here, referral compensation arrangements are permissible. But again, going back to the paramount principle of enforcement of the SEC staff, that if a third party is not a registered broker, they cannot receive transaction-based compensation. Again, that would be tantamount to giving them a salesman stake in the transaction and would require them to register as a broker. So before I turn it over to David to really run with the meat and bones of the Bank Secrecy Act and some of the other provisions of the anti-fraud measures, the funding portals, because they are a broker under the securities laws, are going to be required to comply with provisions of the Bank Secrecy Act that are applicable to brokers, including the Know Your Customer and anti-money laundering requirements. So they have to establish these programs, monitor for and file reports, and comply with requests for information from the Financial Crimes and Enforcement Network. Notably, the SEC staff believes that funding portals will function as a type of broker under the Bank Secrecy Act and anti-money laws known as an introducing broker. So there will be somewhat limited obligations as opposed to a broker that's functioning as a full-blown broker under 3A4. But those abbreviated obligations are not significant, and that's partly because the SEC staff views the type of investors and the type of securities offered through crowdfunding to be in the microcap area, which is a high concentration area for fraud. So as we indicate here, a funding portal is going to be subject to 2- and 5-year record-keeping requirements for the types of Know Your Customer and anti-money laundering data. For 2 years, they have to keep this information readily available on site, and for 5 years, for a total of 5 years, they're required to keep this information, off-site in storage, but still available. The types of information that are subject to those record-keeping requirements includes any and all information relating to any investor who purchases or attempts to purchase securities through the intermediary, any issuer that offered or attempted to offer securities to the intermediary, all materials that the intermediary provides to investors during the account opening process, such as the general description of the offering process, risks, things of that nature. All communications that occur through the platform, whether they're investor communications, intermediary communications, issuer communications, all of it has to be kept. Compliance documents in terms of all the policies required under FINRA or anti-money laundering rules. Any written agreements regarding the intermediary relating to its business as an intermediary have to be maintained. All compensation arrangements with anyone with respect to the intermediary. Daily, monthly, and quarterly transaction summaries have to be prepared and logged. And again, the biennial compliance testing under the FINRA rules that we talked about. And so at this point, I'm going to turn the presentation back over to David, who's going to finish with a run through the Bank Secrecy Act and other anti-fraud provisions.
Okay. I think one of the takeaways from the requirements of the regulation that the Bank Secrecy Act applies, and the question, of course, is why? Why would you want to subject this new arrangement to those kind of requirements are twofold. One is there is a fear that the existence of portals, unless they're accompanied by anti-money laundering requirements and Bank Secrecy Act requirements, would open a hole in the current system, which has arguably done reasonably well at preventing money laundering in the U.S. financial system in the last 10 years. And second, since broker-dealers are already subject to the Bank Secrecy Act, to the extent that you are creating a subset of broker-dealers who are introducing brokers or brokers light, it would be unfair to the existing broker-dealer community to not have them be subject to the Bank Secrecy Act and the AML requirements. What this does do, however, is require a significant investment in systems. And that's, one of the factors in the development or future development of portals is how the market's going to evolve. How many portals will we see? Are they going to be independent, freestanding entities? Are they going to be established as affiliates of existing broker-dealers? And to a large extent, cost, of course, is a factor, and the existence of an established infrastructure by a parent may motivate people to more readily partner or set up a portal under the wing of an existing broker-dealer. Fraud prevention. What are we really concerned about here? The SEC expects a crowdfunding intermediary to play a gatekeeper role and screen and monitor the issuers that are using its website. And crowdfunding intermediaries are required to deny access to their platform or cancel an offering if they believe an issuer presents some potential for fraud. We're in a new area here. These are early days. It's the regulation I should reiterate is just proposed, and it drew a lot of comment letters in the proposal period before it came out. It's drawing more comments again. I don't want to make any predictions as to when the SEC will be able to make it effective, but the industry practices that we will see are still being thought about, let alone developed. If you sort of throw your mind back to the early days of the 33 Act, as an example, and it's not a perfect analog by any means, underwriter due diligence and the existence of everything from comfort letter to document requests to cross-checking customers as a process by which an underwriter establishes a due diligence defense when it conducts a public offering. All of those techniques and practices have evolved over years after the 33 Act was established and have been modified over time, and they've been tested, occasionally failed, in battle, so to speak, in the cases of fraud or litigation. So we expect something along the same lines to appear here, since crowdfunding intermediaries are, as we'll see, are going to be subject to liability exposure, quasi-issuer exposure, in addition to the specific requirement that the SEC wants them to act as a gatekeeper. Crowdfunding intermediaries will also be required to comply with a set of other rules. They're subject to the privacy regulations of Regulation SP, governing privacy of consumer financial information, which means they're going to establish and distribute privacy policies. They're going to have to determine and announce the conditions under which they may disclose investor information, and they'll have to establish procedures by which an investor can opt out of having their information disclosed. They're also going to be subject to Regulation SAM, Limitations on Affiliate Marketing, which allows customers to restrict cross-marketing by affiliates of the portal. That, of course, has real implications for those entities that want to set up a portal to in some way feed investors to other businesses in which they're engaged in the financial services industry. And lastly, portals will be subject to SID, Regulation SID, and have to have a written identity theft program in place. And lastly, liability, which we all think about and have to think about. Both the issuer and crowdfunding intermediary will have 10b-5 liability and under the anti-fraud rules. And an investor can bring a suit to recover the consideration paid for the security with interest or damages if that person no longer holds it, and liability can be enforced under Section 12B and Section 13. The proposing release, notwithstanding that it runs on for, how many pages, Mike?
585.
585 pages, is notable in saying very little beyond what we've just described about the liability issues. So exposure is uncertain. There certainly is no express limitation of liability. And as people have noted, it's unclear how insurance is going to react to this, whether a portal can obtain D&O and entity-level insurance in a manner that will be acceptable to anyone who would finance it. We're going to take questions at this point, but I want to end by saying that crowdfunding fills a niche. It clearly, at least in theory and probably in practice, will be a tool for a company to raise money through an avenue which it had not been able to before. I'll answer one question in the closing. All this effort for $1 million is one question that was asked. Why would you do it? And the answer is, and by the way, the staff was asked repeatedly in the comment period to raise the investor limit. People said, you can't, other than a software development company, you need $5 to $10 million for a startup business. Depending on the industry, you may need more. I think real estate promoters in particular will have a difficult time with the 1 million limitation over the time period. But the staff said it's in the statute. We have sanctioned by the statute to raise the limit every 5 years, I believe. But beyond that, they don't, so they decline to exercise any discretion here. Overall, I think the staff did what they reasonably well with the cards they had been dealt. You know, the limitations, most of the limitations are embedded in the statute. Given the SEC staff's natural disinclination to open up avenues of fraud, remember, that is one of their mandates, and they see, unlike others in the industry, unlike everyone on this presentation and dialed in or looking on, they see fraud every day. We have to deal with the possibility of fraud, but they see fraud every day. So they may have viewed the Jobs Act with some concern, and there's a tension there between what people would like crowdfunding to be versus what Congress enacted, and and a staff that's disinclined to go far beyond the mandate that the legislature established. And with that, we're going to take a couple of questions.
Thanks, David. So we received a question about secondary sales of securities that are issued through Reg CF and how those will be transferred, because as we mentioned before, the funding portal is not allowed to set up a secondary market for those securities. And, the answer to this question is we don't know. This remains to be seen, but, I would imagine a secondary market developing through a similar portal. We have, other online second market is actually a good example, securities marketplaces where these transactions take place. And so I would imagine another, entity or affiliate of a portal would enter this space and create that market.
And just to add to that, Georgia, you don't necessarily need, a market to develop for resales. I think resales can occur with respect to crowdfunding securities the same manner in which resales can occur with respect to restricted securities under existing law that were issued under other, Regulation D exemptions or, different private placement exemptions. And so, if it's a private resale, you would do it as, what's known as a 4.1.5 transaction, or a resale in reliance on the safe harbor under Rule 144, or as Georgia mentioned, and I particularly see this with regard to brokers that are registered under 3A4 who are doing crowdfunding portals may look to become market makers with respect to some of these crowdfunding securities if they see a secondary market developing, and sponsoring them as a market maker, for getting a quotation on the bulletin board or the pink sheets, as long as they get their 15C211 information about the issuer out into the marketplace on a quarterly basis, that they would be able to provide support for a secondary listing. And again, that doesn't require any action or certification by the issuer. That is secondary market establishment activities that a broker-dealer can undertake as long as they can verify and validate the 15C211 info. So we know what we know based on what can happen under existing law with respect to existing restricted securities, and beyond that, what may develop subsequent to that is, as Georgia indicated, remains to be seen what new markets for secondary crowdfunding shares may develop.
Thanks, Mike.
Mm-hmm.
We also received a question about funding portals and whether or not they can receive compensation and the form that compensation can take. And we need to be clear here that funding portals can receive compensation for the transactions that are conducted over their sites. That's definitely anticipated that the amount of compensation has to be disclosed by the issuer, but that certainly was the intention of the SEC. What they cannot receive as consideration is securities in the issuers. So they can't be a co-investor with the investors. They can't receive their fee in equity or debt securities. They must receive it, in actual cash.
One way of looking at this, because of course the question is, how's the portal going to make money? Maybe it's a first mover advantage, but if you're a broker looking at your current broker-dealer compensation models for private placements versus a portal, you have to accept under this rule, the PROS regulation, that the kind of private placement fee arrangement where you get some cash compensation and perhaps some warrants in the issuer is not going to be available under the portal. It's a purely cash fee arrangement. How that drives fees is a function in part of the model, the industry, how well the portal, the people putting up portals how good they are at getting economies of scale and driving down costs and creating efficient models for all of this.
Yeah, my view is that, the portal is either going to collect, a subscription fee for the investors, or they're going to collect a fee from the issuer to list. And I guess, and I posed this question to Georgia because I know you've done a lot more analysis and research on this than I have, is whether you see the fee-based model from the issuer, whether you think it's going to be a flat fee model coming to market, or whether you think it's going to be, as a percentage of, capital raised type of model.
Right. Just in talking to people in the industry right now, there's definitely a sense of graduating the fee based on the level of the offering amount, in the three categories that we described. But whether it's flat within those categories or it's based on the actual amount raised, whether it's based on the target amount raised, whether there's a certain amount of success fee if they receive more than the target amount, all of that is still, kind of remains to be seen. We also received a question, if a company issues equity to many small investors using crowdfunding, won't this make it very difficult later to obtain shareholder approval for changes to the charter, et cetera? And the answer to this question is yes. It will depend on the type of securities that are issued, but this is definitely a consideration that an issuer is going to face when, thinking about doing a Regulation CF offering. If it's going to, be issuing common stock to a lot of individuals, that it will then, have to rely on those individuals to make certain corporate decisions going forward, yes, that's a significant hurdle to those actions. Although, remember, the type of security that can be offered is not, restricted to common stock. So it can be common stock, it can be other equity, securities with different characteristics. And as long as the issuer understands those characteristics and what, risks are associated with that, whether it, has only, voting rights related to certain matters and not others, or is non-voting, or, what those actual characteristics are, really, that's in the hands of the issuer initially and what they think they can sell.
One of the negatives of the portal approach is because you do get a lot of investors in, you haven't dealt with personally or individually, they haven't been screened by a broker-dealer, you're not a public company, and I won't even say you're a quasi-public company, although some people would argue with that given the reporting requirements that you have, since there are some basic reporting requirements. It requires a certain level of maturity on the part of the company management to understand that there are all sorts of things that may happen in the future where they may need to recast their charter, or they may change their business direction, and all of a sudden, instead of having 10 or 15 or 20 or 30 investors, they may have far more than that. And that can be a distraction and a challenge even for the advisor to that fund, because you'll often, this is designed to attract startups. And startups sometimes have highly experienced management that have done it before, although some people would argue that the really highly experienced management teams will not go to the portals because they can raise money based on a track record and they're known in their industries. But startups typically have startup management, so there's an educational process here, which is going to be difficult to deal with.
And I would add to that discussion, David, that, remember, these are early-stage companies, as you noted, and, before crowdfunding, the typical early-stage venture financing round are a Series A preferred, B preferred, where they've got usually convertible preferred with some, information rights, some class voting rights, but generally with the voting rights being, confined to the class, while you have to go out and solicit those votes, it's based on a class vote. And so if you get one or two big fish, in that class, which obviously is difficult with the investor limits under crowdfunding, but I guess the query is whether moving the traditional venture financing for early stage companies from the private realm to the public realm, if it's done through crowdfunding, if that is going to create a movement away from preferred equity to common equity for these types of offerings. And that's an open question that I don't have an answer to, but something to keep an eye out and consider as we move forward. I think one other question I see here is a question about whether we have any sense of the cost of compliance to the issuer for crowdfunding. And I think in large part that is going to depend on how mature the issuer is in the offering process. And it's the development, whether it's a new startup or whether it's been an operating company for a year or two. Again, also how much money they're looking to raise. If they have to go out and get audited financial statements and they've been around for 2 years, that's obviously going to increase the cost. My sense is that the market is going to move to providing products that are relatively, cost efficient. If we're talking about a full-blown $1 million offering, I would have to think between, legal, accounting, and, intermediary costs, that total cost of capital is going to have to be, hopefully less than 10%, but maybe as much as 15%. And again, that just depends on the maturity of the issuer. And don't forget that the crowdfunding rules expressly permit the intermediary to provide template forms and documents. So it's quite possible that if the management team is sophisticated, which is what David was just talking about, and well organized, that they would be much better positioned to generate that information in-house as opposed to having to rely on, the intermediary or outside counsel or the, outside accounting firms to provide, input on disclosure with respect to the Form C information.
Yeah, and I will just note that in the proposing release, the SEC does, go through the costs that it anticipates an issuer will face, and it puts the financing costs between 5 and 10% of the raise. Actually, I think 5 and 15% of the overall raise. So I think the SEC understands the cost involved in this as well.
That number, by the way, will for people who actually read it, and unfortunately a lot of people buzzing around crowdfunding don't read the release. I mean, I don't understand why. It's fascinating reading. That in their minds, they were probably thinking something like 3 to 6 or 7%. The notion that it's still going to be, that you're going to get into double digits here is going to unfortunately scare off some people. I think we've just about run through our allotted time. I want to thank all of you for joining us for this overview of crowdfunding proposals, and everyone have a good day.
This concludes today's webinar. Thank you for attending.
Boom.
How many do we have?